hope we provide you with some really good information, and then some, contact. You can always reach back out to us if questions come up later for you, or anything that comes up around property values. Again, I'm Cindy Braddock. I'm the county assessor, and I have these amazing staff. I actually have a really great office. We have around 50, 60 staff here who are the people who really make this happen. And we're fortunate today to have two really great presenters who are very experienced, have a lot of knowledge to share with you. Ken Beazer is our appraisal deputy, and he's been with us a little less than a year. And Jay Pruett is my chief deputy, and he's been by my side for quite a while, running the office. And so without belaboring it, just thank you very much for your time and attention. And I'll hand it back over to Ken and Jay.
Okay. Jay, do you want to give some more information about yourself?
No. No, I'm fine. I've been with the county for going on 9 years. And before I came to Boulder, Colorado, I was in Taos, New Mexico, where I worked at the assessor's office there for just shy of 7 years. And before that, I started my appraisal career in Southeast Florida, where I spent 21 years.
Okay. My name is Ken Beazer, and I've been the appraisal deputy for about 9 months with Boulder County. Prior to that, I worked with the Colorado Division of Property Taxation for over 25 years. So I have a lot of information specifically on the state level. The state of Colorado Division of Property Taxation basically oversees all 64 counties throughout Colorado and provides education on appraisal methodology, publishes Assessors Reference Library, which is a manual set, which provides all assessors and staff, as well as taxpayers, with valuable information on how the process works and how to value, how to classify, and how to appraise and provide the taxation forms. One of the forms that you were proactively provided with was Understanding Property Taxation, or Property Taxes. That brochure is an excellent source of information from the Division of Property Taxation. It provides step-by-step information that you and other taxpayers and clients can utilize to fully understand the process from start to end. And that information is there. It's also on the Boulder County website. We have major sources of information that you can access, and so can your clients and other taxpayers, to help you understand the process. And we always have that direct number and emails that you can go ahead and share, as well as utilize to go ahead and ask us any specific questions that you may have and your clients may have. So just know we are beyond this specific presentation. We're actually available after this time as well as during, and new values will be released May 1st on the date of the NOV, Notice of Value. So this information is going to be coming. You may have clients, and you yourself may have questions about how those values are established. And if you do not agree with them, the process that you would utilize to go ahead and appeal and potentially abate those types of values. And so we'll touch base upon all those concepts. And so with that being said, we'll go ahead and get right into the PowerPoint presentation. So I'm going to start off with the responsibilities of the assessor's office and the assessor specifically. The assessor is the elected person within each of the counties, and the responsibilities are the same regardless of which county. The first one is to discover. So we're looking at taxable personal property. They have to discover all property throughout their county, looking at all different types of property. And those can include tangible, so physically you can touch those. Those can include intangible, can't physically touch, but they may have a value. Those can include business personal property, which is utilized and taxed separately. And that's where if you have a business, they actually go within or take an asset listing and they value that property. And then you also have an appeal right that's separate from the real property appeal. And they have a separate calendar as well. So just be wary. Business personal property operates a little bit different than real property based upon their data collection, based upon how that information is received and retrieved, based upon how specific taxpayers must file in certain timely fashions. And so they have a whole different set, but that's another type of property that the assessor is responsible for discovering. In addition, there's something called state assessed. You're probably familiar with public utilities. Sorry, that is my inside wife's line that I cannot just hang up on. So I can't control that. And hopefully it won't go off too much, but that third ring is it. Okay. So getting back to the PowerPoint. So discovery, we're discovering all those. The last one I was talking about was public utilities. Those are state assessed and they're valued by the state throughout all counties throughout Colorado. State assessed section of the Division of Property Taxation actually values each of those properties based on unitary valuation. They have a completely different system of valuation, and their valuation includes intangibles, those property value that you cannot touch. Many times public utilities go beyond the state lines, and so they have to apportion throughout that type of property and that ownership from all states that they operate in, all the property goes through. Then they have to further apportion those values to specific counties so that value can reasonably be picked up to go ahead and be utilized within the whole system. So discovery is a big part. If you don't know it's there, you really can't value it. If you don't know it's there, you really can't classify it. And so we want to go ahead and make sure that's a big part of it. So the assessor discovers the property, real, personal, intangible, business, personal property, all classes that are available and provided. And then they list that property. So the listing feature and function actually involves what we call our CAMA system. It's our computer-aided mass appraisal. And this system is similar to between all 64 counties, but there are different vendors, there are different systems, different types of systems that each county has to pay for and keep updated and make sure that they're correct and they're functional, so they can be utilized by staff as well as taxpayers when they're posted onto our website. So they can be user-friendly, clear, concise, and available for public consumption or availability. So it's important that we have that list. We have to start with, we discover, and then we have the list. We put it into the system. We decide specifically, is it picked up? Is the ownership correct? Is the specific details of the property correct? And try to go ahead and put that information in. From the best information that we have, all the data collected from public records, created through sales transactions and TD1000 forms, deeds, other documents that are recorded, we have to take that best information, and the assessors and our staff have to actually classify that. We've talked about a few of the classifications. Tangible, intangible. Can you feel it? Is it physically there? Or is it value that comes in another form, a right that you may have purchased, a stock, a bond, something like that that truly you can't physically touch, but also it actually has a value that needs to be measured. And we have to look at that. And we also look at, once again, state assessed is separate, but it is classified and valued, and our apportionment needs to be considered within our mill levies and our other valuable adjustments and specific collections that are put into place. Then we have real property, which is what this is based upon. This course will actually focus on real property assessment, real property overall valuation and classification. And we'll go more into details about the assessor's office and how we put together the value, how we go ahead and use the data, information, and those sources to truly try to classify it appropriately, and then take that information and value it correctly within a reasonable range. You'll find out when we talk about the value, we have to use, like you said, computer-aided, computer-assisted mass appraisal. We don't just value one property here or there. We value all properties within the county. And so that's quite a few within each county. And Boulder is fairly restrictive as far as the location of the external, where the lines are drawn between that. Broomfield's pretty tight upon Boulder. But we have Longmont, we have Louisville, we have Boulder itself, we have Lafayette, we have a lot of different cities and a lot of different townships and other organizations, other mapping districts, I would say, and levying, legal levying organizations. And so we want to keep that in mind. So value is very important. Classification influences value. Condition influences value. So we'll break out some of that. But overall, the assessor's responsibilities to discover, list, classify, and value all property within the county limits. So how do we discover the property? There's quite a few different sources, and they are public sources. Some are not easily accessible because they may require a subscription or some kind of a membership. But the main sources of confirmation, conveyance, and discovery of real property includes the deeds. The deeds and other types of recorded documents that we should be able to gather information on. That gives us some information specific to the property. specific to what's included, what's inclusive. And we want to make sure that we're always noting what information, because it is fairly concrete and fairly consistent. Permits. When permits are pulled, our office receives and tracks any permits that are pulled, because a lot of times permits actually show changes to the property. Reconstruction, new additions, improvements, refurbishments. These are a few things that will have that information come from permits. And so we monitor the permits, we then follow them up. We do collections, or actually we look at that information, and it's one of the sources that we can use to go ahead and take a second look at the properties. How did it sit as of the January 1st assessment date? What is the condition? What's the legal use? And what influences values? And the permits will give us that information. Just because someone pulls a permit doesn't automatically mean it adds value to the total property. And so we want to make sure that people know that a permit, it's legal, you need to do it, and it is a source of information. It doesn't automatically increase the value, the actual value of the property, but it is something we need to know so that we can consider it when we look at each and specific property. Transfer declarations. These are also known as the TD1000. When you go to a closing, it's one of the many paperworks and legal documents that flash before everyone's eyes. That has to be signed, that must be double checked, that needs to be reasonably thorough and completed by the agent taxpayer, and specifically has to be signed off by either the buyer or the seller, or both. And so you want to make sure that information is correct as possible. If you're the one providing it as the agent, or if you're the one accepting and utilizing it specifically as a source, this is actually one of the main documents we use. We look at the deeds, we consider the transfer declarations, we look at the information's on there, and we pull that into for classification and evaluation purposes. And just to let you know, we will cover this in more detail and later in this presentation. MLS, this is something many of you are familiar with, the multiple listing services. Many people don't have easy access to that. And many of those are listings that are based on metro areas rather than rural areas throughout Colorado. And so those may or may not influence value, but since we're in Boulder, Boulder is directly affected and really maybe impacted, or maybe great information to compare against the computer-aided mass appraisal, CAMA system values. CAMA specifically is based upon a variety of sales information that we receive, qualified, verified sales. By investigating and double checking information, the assessor's office makes sure that we have qualified and verified sales, which are utilized to put into our CAMA system so that we can form models. These models are specific to different types of property, classes and subclasses. Classes may be different geographical areas. As we all know, a location, as they say, that's going to have a high percentage of influence upon the value of properties, whether it's in a subdivision that's new, or whether it's an existing, older, more seasoned, I'd say, subdivision, pre-existing for a long period of time, may influence specifically the type of value. Older doesn't always mean less value. And a lot of people automatically think because it's older age of the building, older age of the specific improvements, it automatically leads to a lesser value. We found that there are some kind of historical buildings that may have that type of additional value because it is historic. Maybe there are requirements or legal limitations which won't allow people to just scrape the property and try to establish a new highest and best use. In those types of situations, we have to be aware that MLS may be based upon a previous type of listing. It may be based upon older information. It may not include permit adjustments. It may not always be based on best information available. And a listing versus an actual concrete agreement and sale contract and specific data that's pulled from that may be significantly different. But it is a great estimation tool. MLS allows people to step outside and have a different third-party source that can provide valuable information from taxpayers, from any appraisers. And our office also takes a look at that, but it's not the primary source of information. It's a secondary or tertiary source that we can double check to see are our values falling in line with what things are being sold and being offered, and try to go ahead and keep our information in check. We also allow it in any appeal at any level, the taxpayer can provide additional information. So if they appeal the specific property value, it can't be based on taxes too high. It can't be based upon, I think your value's too high. Specific details, specific documentation is necessary to go ahead and present to the assessor's office and our staff. And that will be utilized and considered upon valuation situations. Mass appraisal is not the perfect answer. It's not an absolute concrete valuation system. But because we value every property throughout the county, it's the best information we can gather and best system we can use to at least discover and create what we believe represents the reasonable market of all properties that have sold. And that forms the basis for our CAMA system, computer-aided mass appraisal, so we can develop models. The models don't say this specific property should be this much value. It looks into all the specific statistical analyses to determine what actually contributes and detracts from value. And that valuation may in fact be influenced as a mass by something that maybe a specific property isn't impacted by. And so initially a mass appraisal is going to include all properties throughout the county that specifically have value and are not intangible or exempted. And so that information, multiple listing service, is a third-party source, is a hopefully objective source, and it can be utilized and referred to, and even taxpayers can pull it in to be considered where necessary. Sales confirmation letters. Whenever sales occur, we track that information, and whenever they occur, we don't just depend upon the TD1000s. We also have to do follow-ups. And to do follow-ups with sales confirmation, we send out letters. We send them out to the best information source we have on record, the current owner, the new owner that has taken place within the sale. That's usually the best source. That source of information is going to benefit or not benefit depending on what they provide, because if they provide inaccurate information, that may negatively impact not just that negatively or positively impacts all of those types of property, because that helps us determine whether it's qualified or verified sales of that type of property, and specifically where it should be considered in our CAMA system for further evaluation to see if it shows us characteristics and adjustments that are necessary and can be utilized and documented within our system. And so we have to be wary. Sales confirmation letters, they're the back end. They're basically saying, here's what we received, your deeds, transfer declarations, updated permits, any other third-party sources, need to be checked against what's being provided by the public documentation. And so we check this with the best parties. Most time it's the current or new person, the buyer, and many times we also double check against the seller, because the TD1000 should have both, or one or the other or both, specifically sign off that the information coming from those sources is legitimate and reasonable. And so that's the information. We'll talk more about the TD1000s, but sales confirmation, we have to follow up, do our best to make sure the information is valid and the information is good to put in our system. I like to say garbage in, garbage out. We prefer that not to be the situation for our CAMA system. The site and aerial imagery observations, we have a GIS. We have a department for GIS, Geographical Information Systems. We have many tools, one called Prognos and some other tools. They have aerials that they provide. So that information is going to be more updated than some of the other types of sources you find for free online. That's constantly updated. We constantly have our staff double checking, making sure property changes are acknowledged, and that helps us to double check the square footage and our other units of comparison depending on the classification of property. So there's a lot of great information that comes from that. And we have an unbiased, objective department, our division within our assessor's office that constantly makes sure it's good. And we have other tools, once again, different types of digital tools that we utilize to make sure that we can use this source to appropriately take that updated information and come up with justifiable and defensible values. And we don't always just we don't look at the system as perfect. We do want to get all the information from taxpayers and anyone else that provides it, because we are always open to looking and considering what makes sense. We know that each property may have its own specific take or specific influencing values, different types of characteristics that may in fact be observed by a series of properties, but then maybe going outward to subdivisions and even further to other neighborhoods or economic areas, we may lose something based upon the transition from a smaller subdivision all the way to economic area to the entire county. And so we want to do the best with our information to come up with the best valuation. That's why appeals are there and abatements are there in case we miss it. It's not specific, it's specific to that property. And so since we go with valuing all properties with CAMA, we always have to go back to making sure that the appeals process will help us to capture things that maybe our CAMA system did not. Some of the participants that are involved in the process, many of you probably know them quite well. You may actually be one of them. And so we'll talk about some of these. They're common knowledge and base participants that we have within the process. The first one is the buyer. The buyer, there has to be a buyer for a transaction to take place. And so our information from that buyer will be helpful. We talked about the TD1000 or the transfer declaration. That's one of the primary sources that we receive from the buyer. We also look at the follow-up letters, follow-up confirmation, follow-up details that we get from them as another great source to make sure we have the best information to come up with the base valuation and put it into our system to see how it influences other specific properties. So sales that are taking place, hopefully arm's length transactions, are being monitored. We're asking the seller and the buyer, so the buyer and the seller, for their best information with base documents like TD1000, with follow-up letters and surveys to make sure that they are able to weigh in and provide us with the best information possible at the time of the transaction. We also have the other parties involved in closings, including the escrow or the closing agent. And that party hopefully is aware of how some of this works as far as classifications and specific split assessment ratios and valuations and substratifications that we consider. A lot of times those parties may or may not know that. This is a great opportunity, these types of courses, for them to become more aware of how the process works and what the assessor's part of this process and the assessor's practical application of coming up with the values and classifications, and the timing is very important. That may influence the end result of the taxes. And so we will make sure that the actual value is correct based upon these information sources, and that this agent or the person in charge of making sure the transaction is closed and basically taken care of in a legal way has the documents and information and knowledge to go ahead and do it appropriately, and to make sure the buyer and seller involved in the transaction are given the best information, most timely information, are aware of all liabilities they may have within the closing. The attorney, there may or may not be an attorney involved, may also act as the closing agent. So some closing agents are attorneys, and they make sure that the legal side of the equation is taken care of. Not only all the legal documents that are flashed before everyone's eyes at every closing and have to be signed really quickly, usually within an hour. Not only is it that type of situation, but they want to make sure proactively those documents are in order and all documents are taken care of and part of that packet, as well as afterward, all the signatures in the appropriate places. The parties involved are aware of what their liabilities and specifically what they're documenting, so that information can be timely submitted to various public entities as well as put on record. The title company representative, we have one of the situations where the title company obviously has a vested interest in making sure the closing and the transactions line up with what's reasonable. The title company and other representatives may actually have to provide an estimation of the property taxes. So at the point of closing, they have to know the system well enough, understand the legalities, understand the classification, understand how the valuation works, so they can actually provide the parties involved with the appropriate information so that they're not caught off guard, specifically with what taxes are actually issued. A lot of times there's an apportionment that happens when you have a transaction like this. The buyer and the seller have to have taxes estimated so that they know how that can be apportioned based upon the number of days that they've each owned that property. And so with that apportionment, it's particularly important that people are aware. We had a recent situation that I'll go ahead and make you aware of at this time, and it's probably not an inconsistent, occasional situation that occurs. We had a taxpayer who in fact purchased a property. They purchased it in June, or actually in July, and the information, the taxes were pulled based upon the previous taxable value and the taxable classification. You'll find out later that residential classification, those properties receive a favorable 7.15% assessment rate, where you have non-residential, which is pretty much everything else, receiving a 29% assessment ratio. As you can imagine, that increases the specific assessment amount by over three times as much, and that impacts the end result taxes that the owner will be liable for. And so it's very important to get that type of transaction as correct as possible. What a lot of people don't know is if you estimate based upon the previous tax cycle, you may be estimating based upon the wrong classification, because the assessor's office looks as of the January 1st assessment date at the use, legal use, and the condition to determine the specific classification and the valuation base for the entire following year. So if you have a situation where, like this guy did, like this person did, where they weren't aware, the closing agent didn't make them aware, the involved participants and representatives may not have known, or they did not make the seller and buyer aware of the situation. And so what happened was, as of the January 1st assessment date, prior to the time where they bought it, they had purchased the property. It was at a residential classification, 7.15%. It was valued based upon other comparable residential properties. And in this case, vacant land was actually a higher base than the residential improved for this area, for this property type. And so they were surprised to receive a tax bill that showed their liability as $30,000 versus $3,000 to $4,000 of liability. And so there is a bit of a question as to how the process works and who potentially is liable and who should specifically show that information and make sure it's correct. And I would tell you, all parties involved should make sure they're knowledgeable, should make sure that they're aware of the laws, should make sure they're aware of what influences value and how classification is adjusted and how that influences the specific property taxes at the time of the transaction for both parties, the seller and the buyer. In this case, they were not aware of it. They were clearly provided with legal documentation by the land title company as to how they would determine the amount of taxes, property taxes that would be due, and how they would apportion that between the buyer and the seller. So within that situation, they actually valued it. They had the previous value, which was residential, the classification residential, and the valuation based on comparable residential properties as the base. So that actually found that the vacant land which they purchased actually not only had the 29% assessment rate, but it also had comparables that led to a higher valuation. So that's very important in the process. And so it's good to be aware of the timeline. That property was originally a land portion of a larger residential property. And so they were correct initially that that property had been assessed and valued as residential because it was a part that was included as residential with a house that was used residentially and classified and appropriately legally utilized as a residence. So when that previous owner decided to go ahead and break that parcel of land off from the total property, that property now turns into a vacant land property instead of classified residential. And so at that point, before the next assessment date, they were not aware of the classification shift. They were not aware of the 29% versus the 7.15% that they'd now be liable for. And they were looking for who to have as responsible. The assessor's information from the previous cycle is in fact there. But the problem with that is when it changes, it isn't an immediate change upon our website or upon our evaluation or classification. The way the timeline works, which we'll talk about in a slide to come, is you have a situation where there's a two-year reappraisal cycle, and there's assessment dates of January 1st on each of those, and there's an appraisal date that goes into the past. So valuation is determined by a 18-month to 2-year, 24-month data collection period that's prior to the January 1st assessment date, and it's for the next 2 years. So we'll talk more about that to get into detail. But in a nutshell, in this case, the previous classification was correct, the previous valuation was correct, the land title in fact told the new owner what that was going to be based upon, and they had a disclaimer that this is just an estimate of the taxes that would be paid. And so land title specifically did that, made it clear to the new owner. The previous owner also received what we call an NOV, the notice of valuation. The notice of valuation provides the owner each year with the estimated, with the classification that we know as of January 1st, as well as the estimation of value. And so that allows the owner as of November 1st to go ahead and protest or appeal their value if they don't agree. They can also, if they believe the classification should be different, they can also be, that can be part of their appeal. And so we always want to make sure we have the best information, best valuation, and the best classification. And the NOV allows us to put that by the taxpayer, the owner, who is most impacted, to in fact look at that before it's actually certified, and the value and liability is upon the owner. And so in this specific case, the taxpayer did in fact have a timely NOV, notice of value, mailed to their location. Apparently they had not adjusted their location for where they had moved. So the best information we had from the documentation, it was mailed to that address. The previous owner did not notify anyone that they had moved and that was no longer their address. And so at that point, that's all we can do. We use the best information we have on the property of ownership to provide that information to allow them to timely process an appeal. In addition to this kind of chaos that developed, the person in this case bought it in July, and the closing date was in July. The NOV went out in May. They bought it in July. The classification was determined the prior assessment date, which is January 1st, as well as the condition for valuation. And no one had made them aware of the potential adjustment based on classification and valuation consideration. And so they didn't get the NOV. They didn't have anything in the process, though they were liable for the apportionment of the year for the taxes. And so due diligence is required. All parties involved are required to understand the tax laws. The assessor publishes the public information when it is qualified, when it's actually included and part of the record. And that doesn't happen until, unfortunately, after the appeal period and all the way through to the taxes being certified and then distributed, given to the treasurer to go ahead and collect in the following year. And so for this year, the January 1st, 2021 assessment year, you're gonna have a situation where the classification valuation or the classification and condition are determined on January 1st, 2021, but the valuation is actually taking place as of the prior even year, which is June 30th of 2020. And it goes back from that date at least 18 months and up to 5 years, depending on the number of sales that are captured specifically within each data collection period. Within the County of Boulder, specifically for residential, we don't go beyond the 24 months. The 24-month data collection period has been chosen because it fully represents entire transactions for an entire 2-year period. There are hot months and not so much hot or colder months as far as sales. As we know, in a 2-year data collection period, if there's 18 months where you have double collected representative sales, at least 2 years gives you a full 2-year cycle to understand that you are not missing out on or adding certain value data that may not be appropriate. So I always love the fact that we use 2 years, because while we can only use 18 months, the 2 years tell you the big picture of truly what is influencing value and how values are going upward or downward in common classifications, stratifications, and substratifications. And so that's always good to know that there is a reasonable basis, especially for residential. With commercial, industrial, vacant land, depending on the sales, they may go further back, and they don't always have to be the same as residential. In fact, those classifications are considered separate from residential, so they can be separately looked at as comparable types of classes within those classes rather than a residential. And we know there's different markets depending upon the type of property. And so that's why we break those out. And we'll also talk a little about the auditor. There's a state auditor that comes into each of the counties, and they're required to look at procedural as well as valuation techniques and methodologies, and to make sure that that information is in fact in line with what's required by law. We have Constitution, Colorado Constitution, we have court case law, we have the manuals that are binding, and we have the statutes. And so within Colorado, it always starts at the Constitution as to how you define what is taxable and what is not taxable, what specifically is defined in each type of transaction and what specifically needs to be captured by each type of organization and utilized for their purpose within the process. And so Constitution dictates that. Secondarily, we have CRS. It's the Colorado Revised Statutes, and it's the legal documentation that helps interpret the Constitution. That information is published. Both of those are public information. Colorado Revised Statutes can be adjusted based upon laws that are passed, proposed by the legislature, the House, as well as the Senate, and then ratified specifically by the executive branch, which would be the governor. And so they can deny or they can postpone indefinitely, or the governor has the power to go ahead and veto, so forth, postpone indefinitely so it never gets beyond to the next power, or to accept and go ahead and check off on laws that are passed. So we're kind of at the will of the governor, will of the legislator, will of the powers and parties that be in our legislative system and in the political system and spectrum. As we have to be wary that that's going to potentially influence how property taxation and others are influenced. The statutes are not always clear. And since they're not always clear, sometimes we have to go to the next level. The next level down is court case law. Court case law that is published is actually utilized to make sure that things are being commonly, consistently interpreted and applied. And so you have to be aware that's another level that it goes through. So if statutes are being debated as to what they truly mean, those can be put up through the courts, through the process, and then be interpreted by the courts throughout Colorado. The Supreme Court will not hear anything that isn't procedural or that isn't specific to a general designation or general argument. The Court of Appeals has to hear everything. The Supreme Court, in fact, in Colorado, what their cases come up with become court case law. The Court of Appeals, it depends on how hard it gets or if it's petitioned to become considered for court case law. Those that are petitioned and granted as looking at unique, usually not argued before types of conflicts and interpretations, usually will not go beyond the Court of Appeals. Within this, we hope it never gets there. We hope it never gets there because we have a really, I believe it's a taxpayer-friendly and open system to make sure we get the appropriate values. And so beyond that, there's something called the ARLs, Assessors Reference Library. To make it clear and make it more uniform for all 64 counties, the Assessors Reference Library is something that is public. It is created and updated by the Division of Property Taxation with Department of Local Affairs at the state. And it's looked at quarterly to make sure it's updated. Any changes to it go through an approval process through what we call the State Board of Equalization. And so there's a lot of different channels, and people say bureaucracy. It does seem that way, but it's a check and balance system. And truly it's a check and balance system to make sure that each taxpayer, each representative is understanding and given the same due process and reasonableness of their valuation. And so that's something I believe is positive, and it's something that's in line with the Constitution. Personal property, all property and taxation is needing to be based upon uniformity, equalization throughout the taxing district. And so we want to make sure that's always in line. And that's the ultimate constitutional provision and requirement. So we'll talk more about that in a bit. So then we have, we have the mortgage lender also involved within closing. Real estate agents, many times they're going to be part of that as well. And so we're going to look at those parties that are involved, specifically may have liability, may have the knowledge or need to have the knowledge to make sure that they help direct their clients and direct the parties into the right direction and answer those questions. And if you can't answer the questions, our office and other offices like throughout Colorado are always there with experienced, seasoned, and knowledgeable staff that can help you to calculate, figure out even specific property issues in general as well. And so feel free to always contact us. If we don't know the answer, we know who does, and we can definitely put you through to the right parties or give you the information to go ahead and contact those parties. The TD1000 is that transfer declaration that we talked about before in the previous slides, and it is the main source of information, one of the primary sources that we use when a transaction takes place. TD1000 is a real property transfer declaration. It's not just for single-family residential, it's for multifamily residential, it's for mobile homes, it's for other residential classified properties. And when this is completed at what we call at the closings. Once again, it's the closing agent that probably draws it up, the real estate agent that probably looks over it to make sure it's reasonable and in line before they put it by the actual client or the buyer, to make sure that they're going to sign off on a legal document they really understand and that they fully agree to what it is. And so you want to keep that in mind. It's confidential. That means only the parties involved, specifically the seller or the buyer, will have access to the documents that they signed. So we cannot just simply distribute this and share it with anyone. We can't share with tax agents unless there's specifically a letter of authorization. We may have to be able to share some confidential materials with tax agents that have a letter of authorization, or other individuals where the owner or liable party can go and grant that authorization to another party and provide legal documentation to support that granting of seeing confidential documents. Personal property that was included in a purchase price, well, we're trying to capture just the real property value. And so personal property is anything that's not real property. It's always very easy to say that. Personal property can be intangible, but there's still some confusion. So personal property is anything that's included in the purchase price that isn't real estate or real property with all rights included. And so with that being the case, with personal property in real estate, specifically looking at single family residential, you will have a lot of different things, items that you would see, like different types of appliances. You may have stoves, you may have dishwashers, you may have different types of appliances like washer dryer. And if those are standardly inclusive in that type of property transaction, and those types of items are pretty standard, pretty typical, those would not need to be pulled out. Yes, should they be included on T1000? Sure. But when we review it in our office, we look for comparable information and say, is this truly something that's atypical, or should be in fact removed from the real property for this type of classification of property? And so we don't just blindly accept, we analyze the TD1000, the specific information that's provided, and we go ahead and decide if it has an impact, how it's consistently considered within comparable types of property, within substratifications and locations in the vicinity, so that we make the appropriate adjustments that we can defend and adjust appropriately, so that we know, is this qualified and verified for the real estate only? If there are questions that are out there as to whether something includes things that we don't know about, there's gray area, that may be disqualified within the process. And if it's disqualified, it doesn't have any bearing upon our model and how we set those values, are the influences of different characteristics that are captured. And so it's better to have adjusted and given us more information so that we can look at that than it is to leave it blank or provide a generic information on that line. Many times we see things like minimal as to the amount of personal property included within the purchase price. I've also seen $5,000, $100,000, depends on who's filling it out. We also ask for details, not just give us an amount. Specific personal property, tell us what was included. Give us a breakout if all possible so we can make the right determination as to whether it should be included with real property, that valuation, or whether it should be marked differently and removed from the real property so we can value it. And so keep that in mind, is that personal property included. It can also include things like cars. Yeah, a car isn't part of the real property, but in a transaction, maybe that's part of the agreement. And so that type of thing would also be removed. And so the more information as to what's typical, what's atypical, and what's been given, it will be provided if we can analyze the information that you have. Condition, it's the condition of the property at the time of sale. So we want to know, is it in poor condition? Is it in excellent condition? Is it in average condition? Many times most people are not knowledgeable about what condition is compared to other types of property or similar properties in the area. And so we understand that. We understand that that may be a guesstimate, but we'd like your information on what you believe, what involved parties believe as far as compared to other similar properties within the area. And some may be better, some may be not. It's not only whether someone believes it's better or not, whether it adds or doesn't, that's a belief or a thought on one person. It's specifically, consistently how it should be viewed. So you can provide us with the details, documentation, specific information, even position our specific objective thought on what you think the condition is. We will still use our best information. We'll double check it. We'll have our appraisers look at information on other properties within the area. And we'll also have physical audits many times to double check and make sure things are appropriately collected and data is correct. When there are appeals, many times there will be a condition check. We'll go ahead and ask for internal ability to go internally with COVID and maybe having the taxpayer take us on a virtual tour of their property, but it gives an opportunity to make sure it's correct within our system. The better information we have in, the better our mass appraisal, the better everyone's valuation, are more consistent and defensible and reasonable it is, the less appeals, and it helps everybody if we get down to that point. Less appeals helps everyone. We don't look to have multiple appeals. We look to have good values, reasonable values that people can see and understand. That way they don't feel like they have to go through the system and the different appeals and abatements to go ahead and get the value corrected and reasonable. Contact information, we need the contact information of the parties involved, specifically the buyer, because they're the ones at the end of the year that are going to have to sign off and pay the taxes. The property is what the treasurer holds. If the taxes are not timely paid, the liability is there. The liability is there upon the owner, because if the property taxes are not paid for a certain amount of time, there can actually a foreclosure and sale of that property may be utilized by the treasurer to make sure that that amount of property value is bearing its own burden upon the tax system, meaning it's taking care of itself. There is legal ability for the treasurer to seize and distrain, though it's not a condition and option that they choose to have. It is something to make sure that the tax burden's evenly distributed and everyone's paying their fair share. So the liability is there. The current owner will have it. The current owner potentially would have to go back on the buyer if they believe or the seller, if they believe something was amiss and they didn't pick up their portion, as in the case I previously explained. The only person who was still liable on that end was the previous buyer for their apportionment of the taxes that were due. But the current owner bears the burden because their property is there, and if that property is seized, distrained, and sold, they're the ones who truly suffer from the taxes not being timely paid. So you want to make sure that's something that people are aware of. Contact information or anything else, definitely want to make sure that's that information is the buyer, the most recent owner, the person who's going to be liable. We also have the previous owner because we want the best information to provide the documentation timely to both parties, as well as to follow up to make sure that we're on the same page as far as what transaction has happened, what specifically has been exchanged, what was real property, what's not real property, and get down to the very essence of what's included within that property. That way we can look at the characteristics that it's sold with, whether it's 1-car garage, 2-car garage, no garage, shed, whatever the case may be, and to see if that adds or detracts value. So that's some other information. We follow up. We also want to make sure we know who they are. The NOV goes to that person the next May. And so they have the opportunity to timely appeal as well. There's a ability for the assessor to go ahead and assess a penalty when the TD1000 is not timely turned in. And it goes through and all the way through the process. And that amount is $25 or 0.0025 amount based on the sale price. You don't have to worry about what that is because Boulder County does not assess it. We do not have you actually have to pay it. So, but we still want you to timely fill out, complete, and turn in the TD1000. That way we have the best information to come with the best value. So real property transfer declarations. Here's how we look at the things. Specifically, we look at the atypical, something's not normal that steps outside of what we have with other common properties that we've received the transaction documents. We also look at an explanation of how high and low extraordinary types of properties are coming out. So what's influencing those that are atypical and that are coming in. We have something called sales ratios. That's statistically used to determine specifically how the ratios and what's influencing value, how much, and what type of adjustments are necessary. And so what we have there is that the TD1000 helps us pull that condition information, those specific characteristics, real property versus other property, so that we truly have a good idea of what the real property valuation should include, should be considered, should be checked within the system. Just want to make sure that that's as correct as it possibly can be. This is a copy of the TD1000, the first page. Once again, it should look familiar if you're involved in any of these transactions as any of the parties. The form is essentially for information to the assessor. We want it to be accurate, fair, and uniform for all property where it's submitted. Once again, it notes it's confidential, so it's not available for public inspection. We're hoping that'll make sure that it's even more appropriately and honestly and accurately completed, because you know it's between you and the assessor. It's something of public record, but something you have to have grant legal authorization for others to see. And hopefully it's valid and reasonable. We see them all, we see the comparables, and that helps us, influences our decision on whether something is reasonable, qualified, and verified, and what specifically is it's common within this type of property transaction. The form is a conveyance document. It's presented for recording. We're an office of records as well. The treasurer also has that in the recorder's office. And so that gives you additional information as the parties that may need this information to make sure things are done. But the TD1000 is kept with us, kept on file, attached to accounts. So we specifically can look at that and make sure we send it to the right direction, the right people, make sure we know what type of property is. If you look at number 2, the type of property purchased, well, what did you purchase? A single family residence, a townhome, a condominium, a multi-unit residential, a commercial, industrial, agricultural, mixed use, vacant land, other. So it gives you a variety to make sure people know what they're purchasing. And in fact, the case I mentioned before, it had turned vacant land, and it was clearly marked on this document vacant land. But the party did not know the difference between vacant land and residential and the assessment rate, which would over triple his taxes and his value. And so that's something to just be aware of. So make sure this is correctly filled out, and make sure residential, which are single family res, townhome, condominium may be commercial, because commercial condominiums is as residential. That doesn't tell us everything. Multi-unit residential, commercial, anything that's commercial and industrial, those types of properties are very, we need information on those to make sure we have enough sales to test it. And when we don't have enough, we go back to up to the 5 years. And we also use the income approach, and we use the market approach, and we use the cost approach for those types of properties. So all three approaches are allowed to be used. The residential properties, we're only allowed to use, well, we're allowed to consider all 3 approaches, but we can only utilize and apply the market approach. And the market approach is based upon sales. And so that's another reason this is really, really important for residential structures, is because that type of property will be utilized definitely with market and sales capture what the market is doing. Still is useful for commercial industrial because it also helps us to look at that approach and to see how that stacks up against the income approach based on information we receive, as well as the cost approach. The cost approach is usually applied more for newer properties rather than older improvements, and more practical because then there's the subjectivity of depreciation if in fact it's an older type of property. Agricultural has the same 29% rate, but agricultural properties have a favorable valuation. And so that's something that can really come out. And it's dependent on crops that are grown, dependent on livestock. And there's actually a formula that's published in our assessor from the library to make sure that's done consistently. So mixed use, what does that involve? Mixed use for this situation that I'm looking at is residential versus any other use. So you have a residential, maybe like a condo situation, where now you see retail on the first floor. So the first floor throughout this specific complex is retail and restaurant and all that good stuff that can be rented. Above it are residential condo units. So there's a mixed use there. The top is residential, the bottom is commercial. With that type of situation, knowing about the split assessment ratio, 7.15% versus 29%, we need to make sure the valuation is taken care of that way. So residential owners and the units above, in fact, receive the appropriate valuation as well as the appropriate assessment rate. And that the commercial below, the owner of those properties, receive the appropriate updated information and the appropriate assessment rate at 29%. And so we want to make sure that information is captured appropriately. There are a few others that we'll talk about a little bit later. There's multiple different types of properties that are captured. Going on to number 3, the closing date, contract date. That's great information for us to be aware of so that we have the timeline upon specifically where adjustments are made. We have something called time trending that we must apply by law. So we take all the sales that are qualified verified. We go ahead and put that information into a system. It is used to model. And then once we come up with that initial information, we come up with the valuation. We can look at that within a ratio format to determine specifically if there are atypical ratios, high and low, and where we need to focus our limited resources that we have within our assessor's office to try to correct or straighten out within the mass appraisal process. And so we're looking at those dates, which is appropriate, where did the contract take place, where did the closing take place, where was the agreement of the knowledgeable parties, specifically in the transaction, so that we can truly see where it happened. Any type of time adjustment comes based upon our analyses and is applied to those time adjusted, those sale prices to bring them up to what we call the appraisal date. The appraisal date is June 30th of every even year, and that is the base for the next two assessment dates, which is the even year and then the odd year and then the even year. For this specific time period we're talking about, the appraisal date is June 30th, 2020. The assessment date is January 1st, 2021. The next assessment date will be January 1st, 2022. So for January 1st, 2021 and 2022, our valuation information has to come from June 30th, 2020, going back, for this case, for residential, 2 years, to July 1st, 2018. And so that information for valuation is taken that way. For each assessment date, the January 1st dates, we look at the condition and the use, legal use, to determine classification and valuation base. And so that's some different type timing that really throws a lot of people off. The understanding property taxation information, the brochure you received, takes you through this entire process, is very helpful and useful, specifically when you have clients or when you have to look at this and make sure you're knowledgeable and updated with the way the process and the system works. So you want to make sure you keep that in mind. Another reason we need this: correct, verified, and reasonably clearly denoted on the TD1000. The number 4 talks about personal property, which we already talked about, real versus personal. Contracted price, it may differ from the final sale price. So we want to have the final sale price that represents the full transaction with fully knowledgeable parties on both sides and involved in the transaction. This is where you can, the number 5 is where you can list the specific personal property and the amounts that can be taken out, so that we have the true real property values to put into our system. Examples of what you need to potentially be aware of: machinery or equipment, vehicles that were included with an exchange, any exceptional appliances or devices that is atypical for the type of property being transacted and transferred, furnishings that may be adjusted. A lot of properties, residential, are sold unfurnished. And so if it has furnishing where that's not the typical way these properties are sold, we'd need that information. Any other types of things that are atypical, we have additional pages if you need it, but description and approximate value at the time of sale will help us determine that information. Looking further at the number 6, the total sale price includes trade or exchange. An additional real or personal property does it. If so, how much at closing was included? 100% of interest within real property. I'll talk about this later. There's an assumption of fee simple transactions, meaning arm's length transactions with all rights incumbent upon the property duly included within the sale. And so when you look at that type of situation, we want to make sure that it was an arm's length transaction, and we don't look at the real property and all associated and appropriate rights within that real property. So we have to look at that information. Was there a different type of transaction exchange that specifically made this property transaction either increase or decrease beyond what the typical sale price would represent? Was 100% interest? We talked about that. If not, tell us what the difference. Transactions, are they between related parties and acquaintances? A blood marriage, business affiliates, or even those acquainted prior to the transaction. So many times there's a favorable valuation, a favorable sale to the buyer when you already know someone, when you have a connection. And maybe it doesn't go on the market. Maybe it's direct and doesn't even hit the market. And then we still have to look at these sales open-eyed and say, is it typical? Is it reasonable? Is it something that is comparable to the other types of sales for this type of property within this location? I'll give you an example of one thing. I recently bought the home that I've been renting for over 10 years. This property never went on the market. I was the only one who had a chance to buy it. I had a value that was below what the market would bear. And what's typically going on in my area with residences is there's bidding wars. So there'll be an offering price, and then there'll be basically someone will come in, and they'll be within the first day to 2 days. There'll be 8 people trying to go ahead and get it on the contract. making offers, and some want to get it so badly that they'll bid well above the asking price, and others will bid at and see what happens. So in a bidding war, a lot of times the values can go up significantly based upon the demand. Right now, we know we're in the seller's market. There's a limited supply of various types of property, specifically residential. There's a lot of people who still want to get it to owning their own properties. Interest rates are very favorable, and people with good credit who don't want to be exposed to other people in multifamily locations are very encouraged and most likely would like to go ahead and get their own property. So in my situation, I didn't want to move. My landlord had told me they're going to sell it at the end of my contract, at the end of my lease, which was December. So I had a couple of choices. And so I knew him, so I was able to actually proactively speak with them, say, don't put it on the market. Here's what I'll offer. And it was 20,000 below the base sales that were occurring within my location and type of property. So I got a really good deal. Now, if I look at this and I put no, it wasn't involved with anyone who had a favorable connection with the owners before entering the transaction, mine would initially be considered an arm's length transaction and should be included within the data collection period for that type of property. In fact, it was not. In fact, 2 months after I purchased the house for $400,000, the one across the way went up for $475,000. Within 2 more months, around the block, similar house, $525,000. And that was just talking about December of this last year to the summer, to this point at this point. So I bought it in November of 2020. And at this point, properties in this area, from $400,000, they're going to $525,000 as the base. And so that's the true market. That's the arm's length transaction as of this time period. And that could be misconstrued and misutilized and not captured correctly if this isn't appropriately completed. Additional information, looking at number 10, condition of the improvements at the time of purchase. We have new, excellent, good, average, fair, poor, and salvage. So what are those improvements? What level is it at? We don't always know. We don't have the qualifications, but we can guesstimate. We ask for at least your best estimate of what qualification it would be at, what the condition is. Once again, condition is considered as of January 1st to help influence the valuation of each property. So you want to keep that in mind. So do your best, if you fill out this form, to look at what it is like within the comparable types of property within the area. So maybe it is beat up and not really well taken care of, but if that whole neighborhood, those comparable properties are the same condition typically, this would be average for that specific type of property in that area. We don't expect people to be experts, but do your best to give us the best information, T1000, so we can have the best information to plug in our system and make adjustments appropriately and be able to justify and reasonably value comparable properties in the same way. Types of special financing. As we know, different types of financing based upon credit ratings, based upon other characteristics may influence the true amount that's exchanged. We had a few property owners that basically had, like I said, the renters that went ahead and purchased them. They were purchased for above what the market would allow. So there was an agreement, instead of leasing it, let me go ahead and sell it to you, with the acknowledgement that that person, unfortunately the seller, with the acknowledgement that person probably wouldn't be able to hold through on the contract. It would almost be like a short-term lease with additional funds. And so unfortunately, that's something that happens periodically. So we want to make sure that we capture only what is truly reasonable and market-oriented and based. Total amount financed versus that paid for. We have some places that are 100% cash. When you have a 100% cash transaction and there's not a land title, any other type of financing institution involved, it may be more difficult to tell whether it's a higher or lower price paid than the market would bear. And so we want to know about that so we can look deeper into it. Some of the terms, variable starting interest and fixed rates, length of time involved. Balloon payments definitely may influence whether it's truly a market-based transaction. And we look at the typical market type of transaction and the amounts to determine whether, in fact, it should be qualified and verified or disqualified. Marking the appropriate, looking at the appropriate application, seller-assisted down payments, concessions, special types of terms and financing may also influence the amount that was transacted. So we want to keep that in mind. Independent appraisals. Independent appraisals, single property appraisals don't always add up to what the current market and mass actually holds. We've had questions before about specific properties. So I've received my NOV this year And this is the question. I received my NOV this year. I agree with it overall, but I believe back on June 30th, there was a different value. In fact, I bought my house June 1st of 2020. So why is there a higher value, if that's the appraisal date, then I'm given a notice of value as of May 1st? Why is it different? And there are multiple reasons that could be different. Some that I found in my experience have been the fact that people don't understand what the basis for the valuation is. The basis of valuation isn't one sale. The old saying goes, one sale does not a market make. And while it may be the best comparable in single property, in mass appraisal, maybe that sale was disqualified. Maybe there's a reason in our system that it wasn't typical, or maybe the characteristics that are there, the individual fee appraiser didn't consider the entire market, and maybe they just signed off on that. I've also seen certain situations where the financing company doesn't require a specific value. Instead, they require that it meet at least a certain amount. So a sale that is marked for $400,000 in this type of situation, the appraiser doesn't go in to try to find out what value it is worth as of a specific date. They go in to make sure that it is at least as valuable as a certain amount. So if you have a certain situation where the property itself sells for $400,000, the appraiser may have to go in and just basically tell the financing company that yes, it meets or exceeds this amount that you're lending to them, including the 20% above that, so the financing institution doesn't basically get taken for a ride. And if not, there's PMI that takes care of the difference. So that is other important information. Other residential and information like single family, townhomes, apartments, condominiums, we want to know which type it is because we want to have the appropriate comparables to truly come up with a reasonable valuation and adjustments. Other types of things, especially with commercial, franchises and license that may be included within the transaction. And what other things may be involved? Is there installment, land contract, or other things within a contract that influence whether it is a truly arm's length transaction of this type of property or not? Another one we have is the vacant land. Was the vacant land, was there an on-site inspection? What other information can you tell us about that information? And the most important information, what's the buyer's mailing address? This is where our follow-up goes to. This is where we go to for TD 1000 corrections and questions. This is where our confirmation letter goes to. This is the person who's going to be liable, or the people liable for the taxes that need to be paid the following January 10th. And so it's important that we have this best information. This is the one we put on our records. Our public records will reflect this, and it'll allow people to go ahead and check their information proactively and reactively online. And once again, we want the best information so we keep people in the loop who have an interest within ensuring that the property has the appropriate information and receives the appropriate classification and valuation. This information on TD 1000 is confidential, but is used for our purposes to make sure that the NOV goes to the right people have the appropriate right to protest in a timely manner and appeal and abate whatever is necessary, and that everyone involved in the process is specifically knowledgeable and receives timely documentation necessary to evaluate their situation. There's also a manufacturing home transfer declaration, separate type of document, similar types of information. So if you have this type of residential property, you have to know things like how was the home sold, specifically the address, which sometimes with manufactured homes may move, not as much as it used to, because parks are becoming hard to come by, and the costs to go ahead and move certain years of mobile homes or manufactured homes is not worth the difference with setup and so forth. So there may be different characteristics and things going on. Just like a car, a manufactured home has a make and model, so we need to know that information. Serial numbers, HUD information, a year, and length and width, so we can appropriately draw those so we have the appropriate unit of comparison. The date of closing is important, and the total sale for the manufactured home. As you know, with manufactured homes, many times the land is not inclusive of the total property value that's being exchanged. And when you have that situation where it's a mobile home park, where the land is owned by a different party, which in Boulder we have many times that situation, you will have a different valuation for the specific owner of the mobile home park versus the manufactured home. And we don't want to double assess by picking up the same thing twice. So we focus on the manufactured home unless it truly is sold with the land beneath it. So you may have that type of situation. In my experience, one of the interesting things I've done traveling the state as a property tax specialist with the Division of Property Taxation, I was able to travel out to Summit County and other mountain counties where housing is very hard to come by, but cheap labor is what they want. And so you'll see hotels and motels that truly want to have qualified staff, you know, take care of their clients and keep a reasonable desire for certain parties to go and utilize their space. And so somewhere like Summit, you have Breckenridge, and there are a lot of people who can't afford that, but there are a lot of people who enjoy hiking and biking and skiing. And so there are a lot of people who specifically cannot afford to live there, but they love to work there. That's a great place for them to work. So there are places that are further out that maybe in a different county have manufactured homes that are less expensive to rent. I've seen specific areas where in this type of situation, where multiple people, a lot of times college students who want to work temporarily over the summers, are sometimes rafting over the winters and so forth, summers and winters skiing and rafting, they will in fact rent, almost like a college situation where they have multiple roommates, renting the same location so it's affordable for them to have a place to go to within a reasonable distance of their work. And so manufactured homes depends on the type, depends on the newness, depends on specific characteristics. So we want all that information. So we want to keep that in mind. There's also a note that pre-76, pre-1976 mobile homes are not able to be moved and then relocated to another lot or another location. And so pre-1976 built mobile homes, their value is value in use, the value at the specific location, and once it's moved, it has to be, it cannot be used again as a mobile home. And so that's something to be notable if you have those older communities. So the second one we're talking about, I know we got a while to get here, list, which is describing, identifying. We need the physical location of the property. We need the maintenance and updated records based upon the property. We also need the linking property to current owners for assessment. So who is it currently listed and linked to? So we have to correct this and make sure this is correct using TD 1000 and other public sources of information, including our previous information that we had in our system. And so we always want to make sure that's as updated as it can be as well. Maintenance and updated records, that helps us with condition. That helps us to see what's typical, what's not, so we can truly understand what is influencing value and how that specific property is set up and should be valued within our system. Classification. We look at the different types of property. We have real estate and real property. We'll talk about the difference between the two. We have real property versus personal property. We mentioned that. We'll talk in more detail about that. We have taxable versus exempt property. And we have residential versus non-residential property. So the difference between real property and real estate. So real property by definition, or real estate by definition, is all things, including the natural part of the land, trees and minerals, and appurtenance thereto, structures, fencing, and fixtures. So real estate includes the land, pretty much, and the improvements and fixtures, including some of the natural beauties, which is the trees and shrubs and any minerals inclusive. Now, real property, which is what we are measuring and valuing, is not just the real estate. It's also the full bundle of rights. I like to call it SLUGGR. That stands for sale, the right to sell, the right to lease, the right to use, the right to grant, the right to give away, the right to enter, or the right to refuse any of these. So the owner of real property owns the real estate and may not own the full bundle of rights. They may only own a few. Maybe they've sold off or they purchased a parcel of land that already has a legal document that allows someone other than themselves to go ahead and utilize the minerals. Maybe the mineral rights that have already been sold off or separately granted to another party. They may also have limited access. I've come across a few situations where everyone knows Colorado is beautiful. A lot of people from the coast want to move here. There's a specific situation where I had a person who was in the military, closing in on retirement, had visited their friends and family out in Colorado, didn't want to live in metro areas, didn't even want to live in rural areas. They wanted something beyond subdivision. They wanted a secluded area. They knew Colorado was beautiful, and what did they do? They saw something advertised online. So they used their pension and other funding to go ahead and purchase this beautiful lot of land that was not close to anything at all. What they discovered upon coming up to Colorado was that there was no access. They had to go across other people's land and property to actually have access to the property they purchased. So they could not access and build anything upon this lot of land. They also discovered that there was a stream or a floodplain that went through the land. So upon that, they called the Division of Property Taxation when I worked there, and I talked to them directly, and they said, so what can I do? And the end result, they bought it open-eyed, did not verify and qualify. They did not look deeper into what they were purchasing, and due diligence left them in a bad situation. They had court actions if they want to proceed against the previous owner. In this case, they actually had to reach out to one of the owners of property near them and purchase the right to access their property. So they purchased the right to access a dirt road, to get in their property, to have someone help them build something. And so that was additional cost that they had counted on. So that's something to be aware of. In certain situations, sorry, that's my landline. My wife uses it, so I can't hang up. so forgive that. So that's just something to be aware of. If you don't have the full bundle of rights, then they may influence your property value of what you're purchasing. But in our business and for assessment purposes, we assume everything is fee simple. That means it has the full bundle of rights with none of these missing. And so that's something we pick up within our valuation, because we would not know, which ones they have and don't have with the information sources that we have. Fee simple transactions assumes all the full bundle of rights, and all that is not real is personal. So we assume it's all real property unless the personal is deducted, and we're given that information to support that. So what's residential versus non-residential? The classification is a big one. We said it's 7.15% versus 29% assessment ratio. So we really need to know that. So residential real property includes residential land and improvements, including, once again, all the rights associated. Residential land is a parcel or contiguous parcels of land under common ownership upon which residential improvements are located, used in conjunction with. So residential land has to be legally allowed to be used within that classification for those purposes. It has to be actually put to those uses as of the January 1st assessment date. It can, in fact, have vacant land that is used contiguously with the property. So one of the things we get a lot of times is questions is, well, I own this residential land. I just bought the commercial land or the vacant land next to it because I'm preserving my view. So it was worth it to me not to have another house built that took away my mountain view. So I purchased that land, and it's utilized with this because it's not just a buffer. I go over there and I plant flowers. I go over there and I do walks and hikes. And legally, contiguous parcels of vacant land that are utilized with residential classified land are in fact given the residential classification and associated rate. And so now what happens, once again, as the person I told you about before, he purchased a vacant lot that had been cut off and severed from a previous residential property. And as soon as he did that, the classification was re-evaluated. And so that's another thing, once again, be wary of that. Used in conjunction means you actually don't have it separately out there. If you have a space in between one parcel of land and your residential structure, especially if it doesn't have common ownership and it isn't used in conjunction, that land could be valued as vacant land, but your residential property would in fact be residential and receive the favorable rate. So you still have to be wary of that. Contiguous means physically joining and then utilized in conjunction in the same way as residence. So those are some issues. There's a lot of court cases, a lot of disagreements that are had because of whether it's contiguous and whether it's residential or not. Residential improvements, the building or apportionment of a building designed for use as predominantly as a place of residence. So many times there are certain things. There was a case not long ago where a person had bought 160 acres of land. Upon this 160 acres, the only improvement that they had was a shack. They claimed that shack was their residence, and they claimed the adjoining multiple acres of land was used in conjunction with that residence. There's actually court case law that specifically says that is legal, but there has to be a reasonable amount that is associated with the residential improvement. Didn't say what that is, but it said there has to be a reasonable amount that can now be argued as to what that means. But in this specific case, they received 100% residential on all of the land associated with the shed. and so interesting things. We also had a couple of attorneys from Jefferson County. A guy and his wife basically they bought this lot. They put a shell of a home shell that goes on the back of a truck. They put that out there and put it up on skids, and they call it a residence for 20 acres. And that's the only property that was in there. They said they went there on weekends and they went and used the entire land for hikes in conjunction with their residential structure. The Jefferson County Assessor took that to task and took it through the appeal process for classification. And in fact, the assessor prevailed because they could not prove that that's a reasonable improvement that you can use as a residence. In fact, it seemed like it was a get around kind of thing. So that couple actually lost, and they were given the vacant land rate, which is non-residential. It's 29%.
Marley, is it?
Sorry, do you have a question? Somebody a question? Okay. Okay. So we're going to talk about the classification rates, and one of the reasons classification is so important when you deal with our office and taxes in general. So for residential, to receive the 7.15% assessment rate, you have a single family residence, a multifamily, and a manufactured homes that are used for residential purposes and in fact, legally able to be used in that capacity. For non-residential, which is everything that's not residential, it receives a 29% assessment rate. Those include vacant land, commercial and industrial, state assessed and public utilities, agricultural properties, natural resources, business personal property, and anything else that isn't residential. There are mixed use properties, and they have apportioned rates. Whatever is residential would be 7.15%. Whatever is non-residential would be 29%. Commercial, like I've spoken before, there's residential condos above a commercial first floor. See it a lot in downtown Denver. You're seeing more in different metro areas. Aurora has a few too, Arapahoe County. And you'll see that situation where the owner of the building initially owns the entire building. They go ahead and sell off the condominium separately to residential parties, and then they go ahead and lease out the commercial first floor. And so in that case, all of the specific information will lead us to believe that the first floor, based on square footage and unit comparison, will be valued as commercial and given the 29% assessment rate. Those above that are residential would be given the 7.15% rate, and the land beneath would have a split breakout based upon the amount of percentages of use. So that's another thing to be wary of. The land beneath is part of the component of the entire property, and it has to be dealt with considering the actual improvements in their classification. Bed and breakfast is another type of property that you'll see. It's a mixed use. Many times you have a residential portion for the keeper, the innkeeper, or the owner, and their offices and so forth. And then you also have the lodging and the common restrooms and so forth that are associated with the bed and breakfast with their service, and specifically what they're paying for renting out. In that kind of situation, there's unique laws that form around it. A bed and breakfast, in fact, allocated portions for real property, it's considered residential unless specifically designated for commercial guests. And so what has to happen is you look at the owner has to provide information showing what property portions are actually accessed in square footage as an offer to the customer as the B&B. So the common bathrooms are bathrooms separately in each unit, and the bedrooms would definitely be part of the commercial 29%, where everything else would receive the 29% assessment. To do this, there's actually specific laws that dictate that anything, all the land and everything else would be residential if it's a B&B, except for the footprint of the building would have a split ratio, where you'd have the same apportionment based on square footage of residential versus lodging associated with the land. And so you'd have that same percentage breakout for the improvement, that was then put into the land for classification valuation. So there's a lot of interesting things that happen there. And there's also new definitions what a bed and breakfast includes. You have to have at least 13 rooms that, no more than 13 rooms can be rented for it to be considered B&B. Otherwise, it turns into a hotel or motel classification, which is 100%, 29% are, it's going to be no mixed use. So res and ag, okay, res situations where there's a residence on top of an ag parcel. Agricultural has the 29% assessment rate, but it has a favorable income approach valuation. It is valued using a 13% income rate and within the income approach, which considers the specific type of property within valuation. And so it gives you a 13% information rate. And there's something within cost approach, our income approach, that has to be known. And the amount of the rate is a main part within an income approach that influences the value. So the valuation is deducted, the amount of percentage of non-residential is not favorable, but the way that it's included as far as valuation is. It's usually per unit of land and taken to that point where it's definitely given a favorable lower cost per unit, lower value per unit based upon the actual use. And the Division of Property Taxation publishes that information. And there are requirements to become agricultural. Now the residence on top, that specific improvement, would receive the favorable classification and associated percentage. Once again, it'd have to be valued based upon other properties that are comparable and separated to just the improvements. Mass appraisal versus and statistical models. To value this, we're going to use a mass appraisal process because we have limited resources and we want to value all the properties in a timely fashion, the best that we can. So mass appraisal is the process of valuing a universe of properties as of a given date using standard methodologies, employing common data, and allowing for statistical testing. This is based on USPAP, the Uniform Standards for Professional Appraisal Practices, most recent version 2020-2021, Standard 6. So not only are mass appraisers required, but all appraisers, specifically all appraisers have standards they have to follow. And USPAP points that out and differentiates between mass appraisal and single property appraisal. Within that information, we use that to create statistical models within our system. It includes location, land and building characteristics, income data, cost data, market data, and time-related information and sales. And that information helps us to put it into our specific system to go ahead and come up with how strong certain factors influence values, and then how much. And so we can justify the amount and the application based upon the best information with our models. Once again, we don't expect that our models are perfect. We expect that they'll give us a reasonable range and a reasonable initial value. And once again, the appeal process will hopefully resolve those that are distinctly separate and different. Excuse me. So the reappraisal process is going to help us determine what's going on within the whole thing. The reappraisal process involves 5 steps. Sales confirmation is always going on throughout all periods. We are also always looking for sales that have occurred, seeing if they're qualified, verified, arm's length transactions. Making sure that it is in fact representing real property only, and with all specific characteristics and legal considerations. We explore that data. Once it's listed and we capture the data, we explore it to see what commonalities there are between comparable types of properties and specific comparable locations, different substratifications of property, looking from overall class to economic area, and taking that down to neighborhoods and market areas. So there's all sorts of levels we look at, and the more sales we have at all levels, the better our information is and the better our valuation is. So we keep that in mind. So property adjustments. Within the data we've collected, our transfer declaration, our follow-up confirmation letters, we establish what should be in the system. What adjustments do people pay more or less for within the type of property, within the location? And those considerations are evaluated within our CAMA system, within our statistics, to tell us what our outlier ratios and what are in line. And if they're outliers, what is influencing them to being outliers? Is there something that we're not capturing? And our mass appraisal system will help us figure out and understand and justify and support what adjustments add and detract from value in our final valuation and how much. We also then have to use this information to go ahead and set our new values. The CAMA system gives us our initial new values based upon all the information and statistics used to make sure it's the best and most supportable values. That goes out to the individual properties. We set those values considering time adjustments, considering characteristics adjustments, considering the market information, considering the timing of it to come up with the new values, and then we can analyze those with statistics. Then we open our eyes and say, statistically speaking, procedurally speaking, is the data lining up? Is it reasonable? Is it consistent? Is it uniform? And is it justifiable and supportable? So we analyze those many times on ratio analyses, looking at straight line analyses to see if in fact they are justifiable, time trends are appropriate, looking at consistencies. The statistical information gives us a percentage of confidence that we have within how we value property, within adjustments that are made. And so we look at that information open-eyed to see if our values are reasonable. Time trending is required by law. The state, in fact, audits each county upon time trending and whether it's been applied appropriately. It measures appreciation and depreciation over time. The sales that have occurred for us, for residential, 24 months prior to the appraisal date are all considered. We first look, are they qualified, verified? Are they typical, atypical? And should they in fact be considered within our entire system? We look at the June 30th for this last cycle, June 30th, 2020, to determine that appraisal date and determine what sales can be considered. And then we need to research, double check, and read up on the TD1000 and deeds to make sure that it's truly utilized and reasonable for our data collection. So June 30th is a magical date. And that's going to come in when we talk more about the actual calendar. Here we are, the calendar. This is the assessment year calendar. So we're looking at the assessment date of January 1st, 2021. It's where the green first starts. This is a reappraisal year. So January 1st, 2021, all the way to December 30th of 2020, or 2022, is the entire year that we're actually looking to appraise the property. So when we look at this, where does our data come from? We go back to the yellow. June 30th is our appraisal date. And so statutorily, we're required to value properties going back from this date, at least 18 months and no more than 60 months. In this case, because the county assessor's office in Boulder has ample sales, 30 or more sales, to statistically determine that the valuation is correct or reasonable, we choose to go beyond the 18 months to catch in any allowance for seasonality. And so we go a full 2 years. And that 2-year cycle captures any issues that may have seasonality considerations or adjustments. And so that full 2-year period, 24 months, is considered going back from June 30th, 2020 to determine these are the sales that we can consider. All this information, any sales that have occurred, any substratification that are qualified and verified should be utilized for our specific system in our CAMA system and our modeling. And that'll help us determine the base rates as well as the adjustments to apply for each single property appraisal, single property valuation. So what's confusing for a lot of people, and even us sometimes, is the fact that January 1st values are set within this previous time period when you don't actually get your NOV until May. So the people who are getting their NOV starting May 1st, so they'll get it on Monday, that is based on the condition and use, legal use and condition as of January 1st, 2021. That tells the classification and the condition of the property. Then they receive an NOV, notice of value, as of May 1st in 2021. They have an appeal period that goes to the end of August. That's where they get the NOD, notice of determination, if they in fact appealed. Within that, they can take it to other levels. If you don't agree with the assessor's value or classification, you can take that forward, and that would go to the County Board of Equalization. If you don't agree with the County Board of Equalization, you can take that further to a trier of fact. That trier of fact is choice of the taxpayer. It can be binding arbitration, which resolved right at that point with a binding arbitrator who's paid cash out of both sides. It can be with the Board of Assessment Appeals, which is a state department that specifically deals with these types of appeals. They're made up of appraisers, so they're more knowledgeable about the system. And those types of appeals are heard at that third party level. I don't have to have an attorney there. You just have to have the appropriate information, have taken it up to that level. In addition, district court is another option that you can choose as a taxpayer. The one problem with that is they're usually not aware of how property tax law works, and it takes a lot longer within their periods to go ahead and schedule and get it through the process. And so that becomes one of the things. So you get the trier of fact to choose. Most people go with the Board of Assessment Appeals because it's the least intrusive and the most consistent and simplest to navigate. And so you have that information to do that. So once again, January 1st assessment date, January 1st, 2021. In this reappraisal year, going all the way through. NOVs, May 1st, first shot at what this classification valuation for this assessment date year is. NOD, if you go through the appeal process and notice the determination, says basically upon the appeal level you've gone to, this is what your value is. Don't agree? Choose the trier of fact. The length of time that'll take varies. So if you think of all that, this is what you've done. We've taken June 30th, 2020, back to July of 2018. That other data collection period, we looked at the condition and classification and use as of January 1st assessment date. We've given the actual estimated value and classification information by May 1st and with an NOV, hopefully to the right address, best information on file. People are given the process to appeal the initial levels to get a notice of determination by end of August. And then by January 1st, actually by end of December, there's a certification of values. Based upon the taxing entities, there's a mill levy of certain allowable funds. And that certification is finally finalizing the values put in place, except for those that are still being appealed or may be abated in later years. And so at that point, we finally have a value that's made it through most of the process by the next assessment date, January 1st, 2022. And for the 2021 actual tax year, the treasurer bills you as of January 10th, 2022. So there's some confusion with the timeline. People say, well, why does it work this way? The process. There has to be a fair, uniform, and equalized process. And that's why it's built in the Constitution, statutes, and legislature approves and consistently supports this, is because it actually helps to have the assessor and other parties truly gather the data necessary to confirm that they're verified qualified sales and still allow owners to go ahead and protest before they're receiving their actual tax bill. So this is the best one. Other states have going back to 7 years, 8 years, 10 years. In fact, Colorado before 1982 went back as much as 12 years prior to 1982. And then there was a big fiasco when the market dropped out in the late 80s. And so they then determined that it'd be no more, it would be actually within a 2-year period. And so that's when it adjusted for Colorado. So the one additional thing you want to know about this chart, so we've established the value of January 1st, 2021. And then the next assessment day is what we call leading to the intervening year. Each year stands alone, but the actual data that we utilized is still the same 24-month data collection period, June 30th, 2020 going back. And so if significant changes have occurred as far as values going up and down, they may in fact be missed until the next reappraisal cycle. And so there's a lot of times where an up market or down market may cause additional confusion. Many of you probably know in Colorado in 2007, 2008, the bottom of the real estate, specifically residential, dropped out. Many people were underwater. You know, they had a certain amount that they had taken a loan out on, and now suddenly there was a lot of houses on the market. It was flooding the market with houses because people couldn't afford to pay on that. There were a lot of people having to go ahead and relinquish their property because they couldn't pay the taxes or they couldn't justify staying underwater and wait out the time where it actually even out or the market would improve. For my data, I'd actually run the time trending analyses for the state from 2002 all the way up until 2018. I was responsible for running all the different statistics related to time trending for all counties of the 64 that submitted them timely. And in doing so, I did monitor certain markets. And there was a increased dip from 27 all the way to 2013. It took that long before most markets, especially residential, started evening out so that people could then get out, no longer be underwater, and be able to justify taking on a new loan or refinancing, or even being able to afford staying in the same location. So for my estimates and my information, we were looking at June, actually May of 2013, where you had more of a stabilized market and a seller's market. Ever since then, it's pretty much been a seller's market throughout the metro area, which means increasing values based on time of sale, and time adjusted sale prices that are utilized for the basic valuation indicating increasing values. And sometimes those markets have been outweighed because special things like governmental interest rates going below a certain market like we have right now. These are unforeseen before types of situations where interest rates are so low, everybody's buying new cars. I'm amazed at how many new cars are out there, and everybody has a great refinancing opportunities as well as new purchases. They have good credit, they have great opportunities, and so you'll see a lot of markets moving that direction. All right, this is the detail of what that involves: 2-year cycle, data collection period, July 1st, 2018 through June 30th, 2020. That is actually the data collection period that Boulder County has used for residential for these assessment dates coming up, which is January 1st, 2021 and January 1st, 2022. So what determines these? Once again, legal or actual use as of the January 1st assessment date determines the classification, and the condition, which impacts valuation, is also determined as of the January 1st assessment dates. So why would something change between the two assessment dates as far as valuation or taxes? Well, as you know, we talked about the data comes from the same place, but a change in use by the next assessment date, January 1st, 2022, from residential to vacant land, or any other similar type of thing would in fact impact the assessment rate being used. Also, if the valuation was impacted and additional data was collected and an appeal provided additional documentation, that may form a valuation deduction or increase basis. So there's a lot of factors to look at. Let's see if I can get. All right. The county is audited by the state-appointed auditor each year. This year it's Wild Rose, and that's the auditor team. They put in a bid to Legislative Council, who acts on behalf of the state board, and they go ahead and decide who to hire based upon bids that are put in for third parties. The reason for this is to make sure all 64 counties are procedurally and statistically in compliance with what's required. The statistical and procedural requirements are in line with reasonable and acceptable appraisal practices, as well as generally accepted appraisal, basically adjusted and specifically those that are mandated by statute, law, and court case. And so when we look at this, you have the preliminary hired by council as of usually in September. You have the date that their data is due in April. So we're looking at last September, the council was actually, the auditor was appointed or selected. All of our data and information was due in April, so we're still working on making sure the auditor has that, all 64 counties. The final due date for that information is June 15th. That gives the auditor a chance to check all the different 64 counties for procedural and statistical compliance. Their preliminary report goes to the State Board of Equalization on August 1st, and their final report is delivered by September 15th to the State Board of Equalization. The audit requirements include the minimum performance standards, including statistics on median sale ratio, which measures the central tendency of data, where those typical sales are taking place. The COD, which measures uniformity between classes of property and specific substratifications of the same type of property, something like single family versus manufactured versus unitary types of valuations like condos and townhomes. Is there uniformity amongst common types of property? And then going further, is that all the way up to the class of property? So all the way up to the residential, commercial, industrial, and vacant land class of property. And then this PRD, it's a price-related differential. It's a mean-based statistic that measures appraisal bias. That would be basically if you have high-end and low-end homes within the same neighborhood or same market area, this PRD would let us know specifically if the high-value properties are being favored are the low valued properties being favored with the evaluation. So these statistics are the minimum that you have to have. They specifically are dictated and applied to all 64 counties.
Ken?
Yeah.
I need to interrupt you. This class is scheduled to end in 10 minutes and we've got a lot of questions.
Sorry about that.
So I'm going to have to either blaze through mine or we just need to answer the questions.
Okay, let me just hit this. You don't pass the audit if you have a reappraisal order. You have to actually reimburse the state for expenses, and there's payback in excess to schools, because over 50% of schools' revenue comes from property taxes.
And you got a lot of questions.
I apologize.
Deborah, do you want to start asking the questions?
Are we ready?
Yeah, go ahead. And then
We'll try and
most of my slides were pertaining to the NOV going out and how to create your best appeals. So if we don't get to that, I really want to get to the questions.
I apologize, Jay. I didn't mean to take that
Nope,
much time.
go ahead, Deborah.
Okay, here we go. If a sunroom is permitted and has a heater vent, can we count that as finished space?
If you would consider it, it could be used for all 4 seasons. I would say yes, and you just describe if it's a game room, family room, den, or something like that. But if it's being used for all 4 seasons, I would say it would be finished space.
Okay. Next is, why would vacant land be so much higher for taxes? Does the city want more buildings?
I think that's statewide, and I think that what they're trying to do is they're trying to promote development. And they'd rather have a 5-acre parcel to have homes on it where it's generating jobs, it's generating more income, as opposed to somebody just holding on to it. But again, that's the state.
Yeah.
Okay. Next question is, what do we put down for the appliances, and would you put down used?
Ken?
Yeah, I think you can put down what's appropriate. It's subjective. Whatever your best information experience leads you to. We will compare it to other comparable sales in TD1000s to know what's the standard and what's not. So do your best information to provide what you believe is accurate.
What we really want to find out, Deborah, is if there's something in that house or on that property that you paid more for the house because it's there. So if it was like a property that was traditionally used as agricultural and they're throwing in farm equipment like tractors and things like that, we'd want to know kind of an estimate of value so we can kind of narrow down what did you actually pay for the house and land. Next.
Okay, and then this is kind of a compilation of a couple of questions here about writing nominal on the contract. If you don't write nominal, then what's the best?
I think if they write anything at all and we get that information that Ken was talking about, we get the phone number and the email address of the buyer where we can kind of get some clarity or clarification, I think that would be fine.
Okay. What are the typical ways that large landowners lower their property taxation? Conservation easements or transfer the use to farmland, hunting ground, etc.?
Ken, you want to answer that one?
I've seen I've seen ag being the most common that people will go for. There are specific restrictions. You have to use this ag for 2+ current to even achieve and get that classification. And it has to meet or exceed specific standards that are published. And you have to have grazing, you have to have specific types of animals and so forth. And it has to be verifiable as well.
And I agree with them. I think conservation easement, it can be very creative and everyone can be totally different. And then what it does is it locks in that use. So if they can get away with getting somebody to lease out the property and utilize as an ag, that's probably the direction I would point my customers at. Go ahead, Deb, next one.
Okay. If the buyer's contact info is added to the TD1000, is it posted on the county website when you look at the county records?
No, it is not.
No, it's confidential.
We don't. Yeah.
Okay. Okay. This looks like you, Jay. Why would a vacant lot in a developed residential be classified as agricultural, specifically Boulder Hills?
Yeah, I can answer that. And there's an example. In Erie, there was a subdivision that was developed years ago, and the developer had the property used as agricultural, and he platted it out into all these different lots and got this all ready, and then the market kind of turned south. And so he continued using it as ag. So there's a subdivision that got ag because it was being used as ag. So if you classify it as ag, it will be ag as long as you use it as ag. So I just had a realtor call me a couple weeks ago with the same scenario where he was the buyer was looking at a property and wanted to know why our value was so low, like $9,000, when they're going to pay 1.8 million, and it's because it was being utilized as ag. And I told the realtor, I said, you need to talk to your customer and say, find out what they're doing to get this classified as ag, and keep it used as ag as you're going through this whole process to benefit by that. And then when you want to change the use, make sure you do that January 1st, because that's when we check the use. And then it's going to go up, and the tax is going to go crazy. So he appreciated that because he was able to relay that to the client and make that property even a more appealing property.
Okay, so back to the form again. So does that mean that we don't put in kitchen appliances as it is not exceptional? Do we leave number 5 blank?
Again, they could put appliances, used appliances, just so we know that. Again, it's just going to be anything that the house sold for significantly more. And that's why we just would want to know about that.
Okay. When property is transferred to a family member through an estate/trust, not a purchase, how is the value captured?
It's almost like a property that didn't sell at all. So it'll get, the value will get, the condition and everything might get updated. If there's a TD 1000, we contact the buyer and say, you know, the condition or anything will change up and update our records based on that. But it's not an arm's length transaction that we're going to use in our modeling because it was between related parties. But it would get reevaluated in the cycle because of the change of ownership and everything. So we would just update our records. Does that help? Does that sound about right? If the person that put the question, can you shake your head yes or no to Debbie and let her know that I was clear?
That was from Kimberly.
How did I do,
Yeah.
Kimberly?
Okay. She gave you the thumbs up.
Thanks. Yes.
Okay. What if the mobile home has added square footage? Still put the original length and width that is on the title?
That's a good one too, because what's going to happen is we're going to value the mobile home as a mobile home because it is a mobile home, but the additions are going to be something that we're going to want to add on. So this happened a lot in New Mexico. We call them coddled mobile homes because somebody would add to the back and then add to the front. And there was actually a real house being coddled by a mobile home. And we would have to pull that mobile home out of the valuation and have that separate because it had a license plate and everything still. So it gets kind of complicated, but we would value the addition as it is as an addition.
Okay.
Does that help?
That was Marcel.
Marcel, how'd I do? Can't find you on my window here.
Quick question, is a 7.15% Boulder County or?
That is a state number. It's actually kind of locked in for a while. That was set or is not set, but held stable by Amendment B, which we all voted in last fall during the election. And so until the legislature acts, our assessment rate for residential is 7.15%. On all others, it's 29% still, and that's set in the Constitution and state statutes.
What percentage of NOVs are appealed?
About 10%.
How many are successful in the first round?
You know, it's funny, I'm working on press releases right now. So I pulled the numbers for last year. We had about 8,500 appeals last year. About 3,000 of them were adjusted. So we do take them seriously and review them.
But I do want to point out, Deborah, that the assessor level appeals and the Board of Assessment appeals level, which is the county level, we are overwhelmed, short in time, and rushed. So if you have a client that's done this in the past, or if any of you have done this in the past, and it's been very frustrating, you feel like the whole system is stacked against you, it kind of is. It's stacked against all of us. And I urge people to carry the appeal and keep it alive as long as possible, which means filing the third level, which is the state level, which we're given a lot more time.
Okay. All right, well, we've gotten through the questions and it's 1:29. So I want to just, Jay, before you go into, as everybody's here, if you're here for the information, please stay, but please also know that class was meant to end at 1:30. So you will earn your CE, but Jay and Cindy have more information to share. So if you need to leave, go ahead and leave. And your CE is safe, but I would encourage you all to stay.
Yeah, and I promise you, I'll try to blaze through it as fast as I can, and I'll apologize for that, but yeah, I will go as fast as possible.
And Jay
Okay,
hits the skills.
it's yours,
skills
Jay.
wall.
I'll
Okay.
turn off my video, so I'll be behind you. So go ahead and take it.
Okay, so this slide is basically just showing it. Does everybody see my slide first? Deb, can you let me know?
No, we don't see them yet, Jay.
Okay, I have to hit share my screen, don't I? Let me know when.
You are good.
Ah, good deal. Okay, first slide is just a map of the county, mapping out kind of what we've seen over the last 2 years during this reappraisal period, and kind of the range starts at Ward around 6%, and the high is Neverland, and it's around 21%. Again, this is just a broad range of single-family homes. Did it pop to the next slide?
I think you're going to want to hit slideshow and then start from, start from current slide right there, or to the left from current
Here?
slide.
Not here?
Yeah, there you go.
No, hopefully it did it. If it didn't, we'll keep going. Did it go to the next one?
We're looking at enter your location of Louisville, Colorado, assessed home value of 500,000.
Okay, now this is the states, the United States.
How high are
Yes.
your property taxes? Yes.
Yep, and this is just kind of showing state to state where Colorado sits against all the other states. We had a staff member that came here from New Jersey, and his comment was, why is everybody complaining about their taxes? They should live in New Jersey. This next slide shows an example of Louisville and what Boulder County is compared to the state, compared to the nation. Just to kind of, and I like this slide, and if I were a realtor, I'd probably show my property owners this because Boulder County is still pretty good when it's against national numbers. This is another great slide that I kind of earlier told Debbie that I would probably have people, I would hang on to because I'd want to show people if they were getting ready to buy a house, what's the price you're going to be paying for the house against the 7.15 get you the assessed rate, and then the current mill rate to kind of estimate what taxes were going to be. Somebody was worrying about their budget and what they're going to have to spend. This one I'm going to pass by because, or Cindy, do you think I should? It's okay to pass by?
I can just give you just the 5-second overview. TABOR is part of our constitution, and what it does is limits local growth, local revenue growth. So basically any increase in revenue that a jurisdiction wants must go for voter approval, and that's the gist of it. So that's why in the fall, when we have elections, you see lots, the school districts, the fire districts, anytime they want to raise their revenue, they must come to the people with a vote. So you can go to the next slide. This is the Gallagher. So what Gallagher did was it established a 45-55% split, 45% being the tax burden residences carried. But Amendment B that we passed last fall changed that or put it on hold until some decisions are made by the state legislature. So we're currently, and in the foreseeable future until something changes, it's 7.15% and 29%, and we're not paying attention to this ratio. There's no racial study being done until the legislature decides how we should handle this. That's it.
And this is a sample of the postcard that's sent out. If they want a full page one to review, we call the Hollywood printout, they would just need their PIN number, which is right here on the card, kind of like a third of the way down the left-hand side. So that's one of the most frequent typically ask questions, where's my PIN number? So if you have clients or something that are a little confused, you can look like magic because you can say, oh, that's right here. Again, this is the account number. We always want to point that out if people own multiple properties to make sure they appeal the right account, because that's happened before where they put the wrong account number and that's not the property they wanted to appeal, and then they got to the CBOE hearing with information on totally wrong property. So people are going to want to make sure that. Reason for filing. At minimum, you just have to sign the postcard, send it back in and say value too high. Unfortunately, with that limited information, we don't have enough information to really react to it. So we're not going to give as detailed information as possible. What I would tell my clients, the very first thing is review the information on the account to make sure it's accurate. If we're wrong on square footage, if we say your basement's finished and it's not, all those kinds of things, you just want to make sure that our records are correct and correct in your favor. If it's not in your favor, meaning we don't have the finished basement that you have, you might not want to call me, you might want to just leave things alone. Another thing that's really important if you're talking to elderly clients is if they've been in the property for decades, is there deferred maintenance? Is there things with the property that if you were going to list it, you're going to have to fix this, you're going to have to fix that. If they could give us some kind of an addition of a calculation or an amount that it would cost to get it up to a marketable valuation, or so you could market it, they need to let us know that. So if the kids came and fixed the roof, but the ceiling got stains in it and all sorts of repairs would need to be done for it to be marketed, that's the kind of thing that we might want to try to do a site visit to kind of see if we can help the person out. You just want to make sure. Yep, back to this, you can, we're not doing physical site inspections. Obviously, that's because of COVID. We want to protect the property owners. We want to protect our staff, but we're getting really creative. We are doing FaceTime. We're working with CoreLogic on doing where the property owner actually can take and download photographs of conditions and things like that, and it timestamps and geologically says that that's actually where the photograph was taken, and we're utilizing that. We're also, e-appeal helps a lot. We're also have a scheduling thing where if you want to talk to an appraiser or myself, you can call us and we'll make arrangements to contact you or call you to go over things. And we can do something fun like this where I can share a screen and we can go through the inventory of the property and see if we can help make any corrections we need to. Building an effective appeal, that's basically, you just want to make sure that if your client asks you for some sales that happen, we're working on the principal substitution. So get them sales that happen in the right time frame and as close to a match as their property as possible. So if we're talking about a 3-bedroom, 2-bath ranch style house built in the 1970s, if you can find houses that were similar that get sold, that would be great. Similar quality, and again, back to that time frame. And yes, the most important thing would be as close to that June 30th date would be the best property to suggest. These things aren't up and running right now, but in our website, we're trying to do as many tools as possible. If I were the red dot, the subject property, that's kind of nice because you've got all those comparables that are in that same little neighborhood, less changes in influences and everything. Again, property search, a sales analysis tool, comparable sales list, which isn't always user-friendly. I like to tell people, save it to an Excel spreadsheet, set it up to where you can do some data sorting and sort things out. And I'm more than happy to work with the people and kind of walk them through what I would do. I always tell people, pick the 5 things you like most about the house when you bought it. Pick the 3 to 5 things that if you know now, knew then what you know now, that you want me to consider, add those too. So if, let's say, I use this one a lot, it's on the end of a cul-de-sac. People with headlights are coming down the middle of the night shining your house. If that's something that if you've known when you bought the house, that affects what you would want to buy or sell the house for later, that might be something, because then I'll try to find those things in my comparables. So you kind of see I'm trying to match and do that process of substitution. You're going to find ways to calculate. One of the things about the tax estimate calculator, I like to point people to that, because if you're thinking like we have your house at 500, you think it's worth 475, how much really are we talking about? And if you put that in there, the number you feel it's worth, and you find out, well, I'm talking about $100, then you kind of know how much I'm going to invest in this concern. But if it's an error, we want to fix it. Another photograph of the sales analysis tool that will be hopefully up in May when we start this whole thing kicking off. Another scenario where we're just talking about building the appeal and kind of creating your own little grid of sales. Again, mapping out the areas and focusing on things that are similarities. Open space, if you're backing open space, you're going to want to make sure you're comparing apples to apples. This is just a screenshot of our webpage where you can find the comparable sales. Another shot on calculating your taxes. Mill rate, where you can find the mill rate to help calculate your taxes. We're on the extended appeal process, which most people, we've always been that, so most people live in Boulder County are going to know, but there are some counties that aren't on it, so you get your notice of determination faster. But the appeal period starts May 1st, ends June 1st, so if you have clients that are trying to appeal towards the end, just let them know it's got to be postmarked that June 1st date, or it's not a timely appeal. Options they would have, though, is they could wait till January 1st and they could do an abatement. So if you need clarification on that process, that would be fine. The notice of determinations will go out around August 15th, so we'll start getting them that last 2 weeks of August. If you don't get it, contact us to find out. Maybe it wasn't a timely appeal, or we didn't get it. We just want to make sure. Again, I'm going back to that lower part where it talks about the Board of Assessment of Appeals. That's the state level. And that would be very important. If you get your notice of determination for the assessor level, you're going to want to go to the county level, which is the DOE level. And then after that, you're going to get an NOD from them. You'd want to go to the state level. And at the very bottom, it talks about abatements. Colorado is one of the few states where you can abate 2 years prior, which means we can still work on your appeal. The setting mill rates, that goes over where we certify our values. So if people want me to estimate their taxes, it's really almost until Christmas time before we can actually do that. And then, of course, they get their bill in first week of January. This is just a list, an example of the list of all the different people that $1,600 every twice a year you pay your taxes. That's where that's proportioned out. And then, Cindy, do you want to talk real quickly to the senior exemption?
Sure. I believe that Ken sent a flyer to all of you to share with all of you that talks about the senior homestead exemption. So that's a great reference. Our website also has a lot of information about it. The senior homestead and disabled veteran exemptions are both established in the state constitution and in the state laws and the state statutes. Those two programs are managed by the assessor's office. On the year that you apply, you will qualify if on January 1 of the year you apply, you are 65 years of age already, and you have lived and owned your home as your primary residence for 10 years at a minimum. So those are what we look for. Those are really the only criteria to be included in the program. So I just asked Jay this morning, my husband just turned 66. So he applied January 1, he was 65 already, and we've lived in our home for 30 some years. So he will qualify. I asked Jay and he said, well, I've only lived in my house 4 years. So Jay would qualify if he had been there 6 more years. So it's just something to note. And those rules are set up in the laws and we can't change them. There is, if you timely apply and the application for the senior exemption ends July 15th every year, you have a right to appeal. If we deny it, you can go to the County Board of Equalization and say, yeah, but my case is different. And the board will hear that and make a decision about your exemption. But most people apply in a timely manner and are approved based on the criteria. You only apply once in your lifetime. as long as you stay in that home. If you move, you lose the exemption. It only applies to the home you've been in for 10 years or more. You can't apply for more than one property. You can't have it on your rental home in Estes Park and your primary residence in Louisville. It's only one of them. A lot more about that. The flyer will fill you in on it. The senior tax deferral is a state program that our county treasurer, Paul Weissman, manages. I believe the deadline was in March to apply for this, but this is a year-by-year deferral of your property taxes, and it's in place to help people who are in a time of need and cannot afford to pay their taxes that year. You don't have to do it every year. You can sign up year by year. It has very, very low interest rate, but it does put a lien on your estate. It does put a lien on your house. And so it's something you know, if you have clients with family, it'd be a good thing for their family to know that they're doing this. We have some people who choose to do the deferral for a wide variety of reasons. There's certainly the folks who need it financially, but there are those who just choose to do it because they figure their estate will pay the taxes that they have deferred. The property tax rent and heat credit program is managed by the Colorado Department of Revenue. It does have income levels associated with it, but basically what it does is it offers for people who are at lower income levels. It offers some support for payment of taxes and rent and the sort. But again, that's the Colorado Department of Revenue that you contact. LEAP is a program that's managed by the Boulder County Housing and Human Services Department. And what they do is they help with winterization and heating costs. So it is called the Low Income Energy Assistance Program. And so that's a great one if someone's in a home and they've got, you know, some needs around weatherization, they can reach out to this program. And the very last one is a Boulder County Senior Tax Worker Program. This is actually a program that any taxing jurisdiction can participate in. It allows seniors, qualifying seniors, to work off that jurisdiction's portion of their taxes. So for Boulder County, this is managed by the county commissioners. People who apply and get jobs with us earn $10 an hour. They can work up to 100 hours. We pay them. It's sort of on your honor. We hope you're using it to pay your taxes, but we don't follow up on that. And a lot of seniors do this because it gives them, not only does it give them help with their taxes, but it gives them a social outlet. You might be working on the county trails or working in the community gardens around the county buildings, or helping with return mail and things like that. So it's not very good pay, but it does give them some relief. So that it did that really quickly, but it's kind of nice to know that there are things that we can help our seniors with. We are in a county with a very high cost of living, and it is hard on our older adults who are still in their homes. And it's nice to know that there's programs to help them. So I think this is our last slide, and thank you for your attention. And if there are any more questions, we'd be happy to answer them.
Cindy, there's one more question up here in the chat that's asking, are senior exemptions higher in other counties?
No, it's a state program. So it's the first, it's 50% of the first $200,000 of value in your home. So basically you get, the state backfills that portion of your taxes. So the state of Colorado is paying that piece. It's around, you know, it depends, around $600–700 a year to a senior. That's a lot of money to a senior, to some seniors. So it is statewide.
But it's different from state to state.
Oh, absolutely.
I own properties in multiple states, and I want you to know there are a lot of people out there that aren't even aware of this, because a lot of times before COVID, when we'd have the appeal period, you kind of like gingerly asked if they were over 65, and you'd look to see that they were in their house over 10 years. And you became a hero because they just came in to complain about their valuation and their taxes, and you educated them about that. So if you have clients that you know have been in their house 10 years and they're over 65, ask them if they're taking advantage of it, because you'd be shocked at how many people aren't.
And it is something that's funded every year by the legislature, the state legislature. So we wait for the legislature to say, yes, we'll fund it. never goes away. It's in the Constitution. It's just a matter of whether they put money towards it or not. And it has been funded for the most part. There were a couple years back in the 2000s, early 2000s, where the state didn't have budget for it. But in the last, 10, 12 years, it's been fully funded.
And then Marcia, do you want to go ahead and unmute yourself and ask your questions?
Sure.
Jay, these are the ones I had given to you, Mr. Pruett, to answer earlier. One, Cynthia already answered the one about the new tax laws not starting yet.
Yeah.
The other, one of them was about LLCs. Once upon a time, I had heard that if a buyer buys with an LLC, somehow the doc fees are not getting recorded.
Ooh, that's a good question. Cindy,
That
would
would-
you know the answer to that?
That would be a clerk and recorder question. The law says that any transaction where there is money transferring hands, there should be a doc fee charge, but that is really a clerk and recorder recording division law. And we get our records from them, so I'm not clear what their policies are.
Okay, and the other one was, if you sell like something to a nonprofit, let's say it's just a residential house going to a church to use, the taxes get changed or the assessed value gets classified differently for a nonprofit, or?
It depends on the nonprofit. So many of them, if they're charitable, educational, and I can't remember the third, they must apply to the Division of Property Taxation for exemption, and the application forms and how-to documents are on the division's website. So say a church buys it and they want to turn it into a, their church building, they would need to apply to the state to get that exemption.
Okay.
There are some things, say it's the city of Boulder that buys it, that's automatically exempt. So
Okay.
there's some things exempt under the law and some things exempt by application.
And
So-
it's prorated too, right, Cindy?
Yes, we would prorate it for the year. So,
So Cynthia, you had talked about that new tax law. So right now it's not going into effect, but when you looked at it, how do you think that's going to change the amount that residential properties have to pay? To me, it sounds like they have to pay a lot more.
I have no way of knowing what's going on in our legislature's minds. Certainly as an assessor and along with other assessors, we'll do what we can to protect the ratio between commercial and residential, but it really it's part of the legislative process, and I have yet to see a bill, or there may be working groups, but it's nothing that's been made public or I've been made aware of. So I really have no idea. The way it stood before it was passed, we were going to keep ratcheting residential down, which is great for residences. It's not so good for commercial properties, which we also rely on. So
Right.
I'm sorry, I don't have an answer. We'll have to wait and see what they do.
Thank you.
You bet.
Thank you all. Anybody have any other questions? And I apologize for being rushed. Well,
It's all right. It's all right. We appreciate your attention. It's great.
And thank you, Cindy, Jay, and Ken for your presentation today. We appreciate it. And thank you all for joining us.
You bet. And if you have questions or you want us to come visit with you or cover a topic, don't hesitate to reach out. We'd be happy to do that.
Very good. Thank you.
Thank you. Have a great day.